You are muted. अब आपकी आवाज सुनाई नहीं देगी।
हेलो
हेलो।
हाँ कल्पेश जी नमस्ते।
नमस्ते।
डॉक्टर अतुल दिस साइड।
या बोलिए।
मला इयरफोन देता?
हाँ पंच,
Yes, sir.
मला एक क्वेश्चन है. I just wanted to ask. Hello.
हाँ बोलिए ना.
If there is a call on mobile, meanwhile if webinar is going on the laptop, then what is the modality?
You talk to Krupa, sir.
Okay, thanks.
Green అయ్యింది.
Good afternoon, sir.
Good afternoon. Is this fine? Is it clear?
Yeah, it is clear. We will start in another 4 minutes, exactly at 3 o'clock.
You know that screen sharing link that you had initially given me,
Uh-huh.
that has not appeared as yet. So if you can request your colleague to enable that.
One second. Sir, please check now.
Appeared, yeah. Turn it on at the right time once you finish your introductions and so on, right?
Yeah. And now, is it enabled?
It's enabled. I can see it now.
Okay. Sir, with your permission, shall we start the session?
Ready to start.
Thank you so much. Good afternoon, court manager colleagues. Good afternoon, Sri Professor Dr. Sudhir Krishnaswamy, sir. Today we have gathered here to have a guidance session from Professor Dr. Sudhir Krishnaswamy, Vice Chancellor, National Law School of India, University, Bangalore. Sir will guide us on international justice delivery standards and how court managers can help meet and fulfill the international standards with regards to the judicial reforms in India. I now request Dr. Kalpesh Kumar to introduce the sir.
Thank you very much. Am I audible?
Yes.
Yeah. Thank you very much, Mr. Punch, for giving me this opportunity to introduce Professor Dr. Sudhir Krishnaswamy. Professor Dr. Sudhir Krishnaswamy is a Vice Chancellor of National Law School of India, University of Bangalore. Sir did his undergraduation from the National Law School of India, University of Bangalore itself, and after the graduation, he did a Bachelor of Civil Laws, followed by the PhD from the Oxford University. Sir's area of interest are constitutional and administrative law, property law, legal education, legal theory, and legal system reform. Sir teaches political philosophy and politics in India, law and governance, and the legal system reforms. Sir is taught as a prestigious institution of India and abroad also, like National University of Judicial Science at Kolkata, Aziz Premji University at Bangalore. He has been teaching fellow in law at Pembroke College at Oxford University and Dr. B.R. Ambedkar, visiting professor of Indian constitutional law at Columbia Law School. He also worked in Prime Minister Committee on the Infrastructure and the Kasturi Rangan Committee on the Governance of Bangalore. Sir is a co-founder of Center for Law and Policy Research, which is one of India's leading think tank based at Bangalore. Sir has authored a book, a very famous book on like a democracy and a constitutionalism in India, published by the Oxford University in 2009. Sir has published many articles and policy papers on various contemporary issues in leading journals and weekly. So with this short introduction, I, on behalf of Court Manager, welcome Professor Sudhir on this webinar. Sir. Over to you, Mr. Punch.
Sir, I
We
request
just avoid.
Sudhir Krishnaswamy, sir, to begin the session.
Yeah. Shall we go ahead?
Yes, please, sir.
Good afternoon to all of you who have joined this session. Thank you for the gracious introduction, Mr. Panchakshari, as well as Dr. Kalpesh Kumar. The long and elaborate introduction, but you would have picked up from that introduction that I don't have the levels of experience that most of you have to be able to give you guidance as such. What I can share with you is the time that I have spent researching and engaging with courts and what have I learned in that process. And hopefully through this process, we can have a more elaborate discussion in the time that we have after this process to gather some notes about what might be viable ways forward. Let me begin by saying that I'm slightly embarrassed that I have not done a study on the court manager experiment so far. I do understand that it was the 13th Finance Commission which began this process of appointment of court managers. But I have done, and I have done a fair bit of empirical work on Indian courts. I have not focused on the court management and court manager institutions and looked and understood how you do your work, what limitations there are, and what potential there is. It seems to me that just from reading the basic literature on court managers, that the court manager innovation is a crucial innovation for several reasons that I will address today. And I look forward to hearing more from you in the discussion session about how we might further develop and improve the role that you play in the context of court reform. What am I going to do today? I'm going to share with you, and I'll just do my screen share at the moment. Okay. I'm going to focus in my discussion. I trust my screen share is working. I'm going to focus in my discussion, to kick off that discussion, on justice delivery standards. I'm going to think about what court managers might have to do with Indian legal system reform, though I'm not going to directly address the role of court managers in this process. I understand from Mr. Panchakshari that I will have another opportunity to engage with you, maybe in the coming Sunday or soon after, where I will spend a little more time talking very specifically about the role of court managers. In today's session, I'm going to focus on the first part of that justice delivery standards. How should we think about justice delivery standards? What are the various standards of some know about the standards apply in the Indian legal system context? And these are the two things that I'm going to focus on in my session, and I'll roughly take the same amount of time. I'll spend about 10 to 15 minutes on the standards available, and I'll spend another 10 to 15 minutes time on what my research and other research in this field can teach us. Right? So let me get started. So when we think about justice delivery, the first thing that we might be struck by is the plethora of standards in this field. And for those of you who deal with these questions on a daily basis, I'm pretty sure you must be aware of this rather mixed up field where very different organizations develop very different ways of measuring justice outputs. So let me start with the oldest one, which has been in, at least in Indian legal system reform discourse, all the way back to the 1800s, which is a focus on pendency figures. Very often, we think that the only relevant measure, how many cases are pending in court. This of measure in 18th could come with limited jurisdiction just to handle a few civil matters, that too between your people, and that ought to compass in jurisdiction of the court. And the reason, what do we learn from that early 1800s experience? We learn that, we have a kind of fabled sense of Indian, where we think that we have kinds of institutions, traditional institutions that do a fantastic job of dispute resolution. Find in the 18th moment the East India Company formal court, Indians quickly up these traditions, formal courts, and that trend continues unabated in hundreds. How much ever we talk about traditional disputes, so
You are unmuted.
no doubt.
अब आपकी आवाज सुनाई देगी. You are muted.
trying to share my camera. All right now?
You are unmuted.
Yes.
अब आपकी आवाज सुनाई देगी.
Can
You
I
are
check
muted.
if the
अब
slide is
आपकी
also
आवाज
coming
सुनाई नहीं देगी.
or not?
You are unmuted. अब आपकी आवाज सुनाई देगी.
Slide
You are muted.
visible or
अब आपकी आवाज सुनाई नहीं देगी. You are unmuted. अब आपकी आवाज सुनाई
So
देगी.
it doesn't matter if
You are
yeah?
muted.
Is it
अब आपकी आवाज सुनाई
I-
नहीं देगी.
I'll just go on without the slide. Is that all right?
Sure, sir.
You
No
are
issues.
unmuted. अब आपकी
So
आवाज
I will use
सुनाई
the
देगी.
slide because I feel slide
You are
sharing is
muted.
causing some
अब
bandwidth
आपकी
type
आवाज
problem.
सुनाई नहीं देगी.
Again,
You are
it gone
unmuted.
off.
अब
I think
आपकी
because
आवाज
of some
सुनाई
slides
देगी.
sharing type.
You are
Okay.
muted. अब आपकी आवाज
Is that
सुनाई
all
नहीं
right,
देगी.
Mr. Panchakshari?
You
No
are
issues, sir.
unmuted.
Without slides,
अब आपकी आवाज
we are fine.
सुनाई देगी. You
So
are
what
muted.
we learn from that
अब आपकी
early
आवाज
1800s
सुनाई नहीं देगी.
experience is first that the Indian people were very readily willing to go into the formal court system in large numbers, even when they were not expected to, even when that court system was not particularly designed for them. The second thing is that the problem forced underdeveloped legal system is at least 200 years old in this country. We may imagine the colonizers, the British, had no particular in developing a well worked out legal system, a court system. But it is even 7 after independence, we're still stuck with the same problem. So if we go all the way and look at, if I'm not mistaken, the Fifth Law Commission report, the lament on reform is the same, pendency delay. So we might want to ask, what is it about this pendency structure that has for such a long time? So the second issue is that whenever we focus on pendency and delay, we focus on what is called a supply side. Supply side means that we focus on the supply of dispute processing institutions and courts. So the answer to reducing pendency and delay that is constantly produced in the Indian policy literature is increase the number of judges, increase the number of courts, pendency will go away. Now we have witnessed in the last 7 decades a constant increase in the number of courts and judges at the Supreme Court level as well as at the lower court level. Maybe not to the extent that people might desire, but nevertheless, this increase in inches has not resulted in a decrease in pendency and delay. And we must seriously ask the question, why has this occurred? And it might be because the way we understand what is the problem of justice delivery in India is flawed in some ways. We have a supply side focus. We focus primarily on court increasing the frequency and the number of cases being decided. Now so this is the first framework that I'm discussing. You know that like this, the reigning framework, which you find referenced in the last 3 budgets continuously, is the framework arising out of the doing business reports. Now, the doing business reports, which I'm not sure how many of you have had a chance to look at and study, but doing business reports are prepared by the World Bank. They have some quote measurement, quote outcomes measurement analysis that goes on. But overall, you would have to say that doing business in India reports have no serious data set. They just focus on 2 or 3 cities, Delhi, Bombay, and as I understand it, in the latest Doing Business in India report, Bangalore, 3 cities. They do a very small dipstick survey of some practitioners, and then they publish what is about contract enforcement and kinds of statistics in India. And my suggestion is that a close reading of the Doing Business in India reports would tell us that there's no serious data set there. We can't really understand what the problems might be in the Indian legal system, and there are no serious solutions there either. When you say I want to reduce the average, let's take a proposition, I want to reduce the average time taken for a contract enforcement of money recovery to 18 months in the court of first instance. Let's just take that as an example of some goal. How are you going to do it? There is absolutely no guidance or analysis in the Doing Business in India that can help us do it. This is the second framework. So first I spoke about the pendency in courts framework. Second, I speak about the Doing Business in India reports. I'm sure many of you are aware, at least because this has been discussed in the newspapers in the last few years. The third method of assessing justice delivery is a very famous and well put together international index called the Rule of Law Index. I'm not sure how many of you have had a chance to see this. This is a Geneva-based organization called the World Justice Project, which puts out an annual, very carefully put together Rule of Law Index. Now, this Rule of Law Index is very smart in the range of data that it considers. It considers data across the board, civil contract, business law type cases, as well as and constitutional law cases. So it covers the entire range of cases. It looks at the available data seriousness. And then what it does, it gives us a cross-country comparison of how well has the Indian system, Indian court system, Indian judicial system delivered. This I would highly recommend to you, not because it has a causal model, by which I mean plus the Indian system. But what it tells us, at least relatively, we know that the Indian system is reasonably good at protecting liberty of individuals compared to, say, China. China, the Indian system is not very good at protecting, at contract enforcement. The Chinese system is much quicker and much more efficient on a question like contract enforcement. So at least what we get is we get a comparative picture. So you don't always have to compare with Singapore, you see, or Northern Europe, which do very well on these indices. But even when we compare with countries that a comparison would be useful, Indonesia, some countries, China, we get a very good idea that the Indian system is still suffering in some areas in a serious way. Now, Rule of Law Index, which is freely available for any of you to download and review, is rigorous with its treatment of data, but once again has no causal model. So you're not going to get an idea of how can I reform the court system by looking at the Rule of Law Index. You can get a fair picture of where the serious problems lie. This is the best that we can get. And we can at least see how comparable countries in other parts of the world are doing. and try and learn from them. The next model, interesting model, and I'll call these access to justice reports. Access to justice reports are not prepared on it's been done on several jurisdictions. Closest to us, the jurisdiction is Bangladesh. What is an access to justice report? How from a doing business in India, a rule of law index, or a pendency in courts type analysis? And access to begins from the other side of the problem. It does not look at the supply of legal dispute resolution services. It looks at the demand. What do people really need? The only way you can do an access report is by focusing on a broad survey of the population. If we went and did a broad survey of the population and asked them, do you think you have a legal dispute of some seriousness that you need resolved in a court? What percentage of people would say yes? And then if we ask them, why would you go to court or why would you not go to court? We are going to get some explanatory understanding of the reasons for access to court or not. When we get the differential between the number of people who have serious justice needs and the number of people who go to court, we get a very good picture of the gap. What is the access to justice gap that a legal system is confronting? Now, when we think about India, we have good belief that this access to justice gap is quite serious, quite large. But unfortunately, till date, no such nationwide survey has been done with any empirical rigor. So we don't have a measure. We don't have an understanding of what that figure would be. I've said, I use the expression demand side. I said access to justice reports have a great advantage on the demand side. They focus on what people need, what kinds of dispute resolution services do people need, and what hampers the access to court. Very different from what the other studies that I've discussed so far focus on. The last study that I want to focus on in this assessing justice deliveries is to look at the latest report published by the Tata Trusts and others, which is a justice ranking of states. I'm sure many of you would have seen this, and you might know where Maharashtra fits or Delhi fits. And what they tried to do in this report was to develop a rank ordering of states on various parameters of court delivery. What was the data that was used in this rank ordering of states was the data available. Produced by people like you and the NIC. The data produced, they didn't generate any new data. But they have organized this data and visualized this data in an interesting way. To my mind, the justice ranking of states doesn't reveal anything very new that the pendency literature, which I first discussed, doesn't already reveal. But it is better visualized and better organized, and to that extent, worth paying attention to. Unlike this access to justice reports, which I just spoke about, and I used Bangladesh as an example, the justice ranking of states has no data on what are the legal needs of the people of India. That data is not there. So though they use the language of justice, what really it is a measure of is a sort of a doing business in India with better data. What a measure of, right? So let me on to my next platform. Roughly, I'm 20 minutes in, maybe a little less. I'll move into the second half of what I want to talk about, which is research on what works. And let me suggest you some different approaches, and at least from what we understand from an academic point of view, where the promise of future research is. So there are broadly two kinds of approaches that may be taken to understanding the system reform, and understanding and both and proposing solutions that can potentially work. The first kind of approach is to work with large data sets and statistical analysis. For example, maybe what we should all be doing is to extract the data from the National Judicial Data Grid, which I'm sure all of you understand very well. And I feel people like me have a lot to learn from all of you about what is the National Judicial Data Grid capturing or not. But the eCourts database, the National Judicial Data Grid, they capture a lot of data available at court level or at consumer court level, and so on and so forth. When we look at this data, we can try and scrape that data using new software, a Python script, and then consolidate all that data into Excel sheets, put them into a large statistical software package, be Stata or whatever else one might be comfortable with, and then run statistical analysis on this data. Now, as someone who has spent the better part of 10 years doing this kind of work, let me make two broad observations of what we have learned. The first thing we have learned is that the data that we are able to access from this eCourt system and judicial data grid or the consumer court websites is extremely poor. And it's extremely poor in very many ways. First and foremost, it is not comprehensive. So, for example, if I say that there are 13 civil courts in Bangalore urban district, individual courts in my district, the city that I live in, is this data available for the same periods in the 13 courts? When you get into the and the data grid system, you will not get the same data. The cross comparison between courts becomes very difficult, even in the same city, even in the same system. So the data quality is very uneven. And if you get in a little more detail and ask, why is the data uneven between court and court? And then if I magnify that nationally, some district courts put out no data at all onto the National Judicial Data Grid. The coverage is uneven. The only explanation may be that this is an uneven characteristic is because of the quality of court infrastructure available. This data poverty in the judicial data grid and elsewhere has meant that we don't have any deep insights that we can draw from large data sets and statistical analysis. The data available, I'm willing to say that we need some better models of analysis. We need to refine and improve the statistical models that we bring to these data sets. And maybe the new technologies of machine learning and AI may be quite useful in this respect. And we might, in the years to come, have a grip on the problem of justice delivery by using this large data set method. The second method that we could use is to do studies. And these small case studies can be both quantitative and qualitative. For example, let me discuss two studies that I have been a part of, the 80s and then going on into the one is they imposed very serious costs. They imposed costs on parties for including court time. So let's imagine, you as a court manager, your salary is X. So for every hour of the working day, the the part of your salary, I'll just put a number on it, 2,500 rupees. So you have to pay 2,500 rupees to court manager. If there is some court assistance, you have to pay 1,200 rupees, 1,200 rupees per hour. You might have to pay 8,000 rupees an hour. And for the courtroom and the air conditioning, the facilities, you might have to pay something like, say, let's assume 3,500 rupees an hour. Every single cost which was fixed and placed on the parties. Moment you do this, litigation becomes very expensive. And when you make it very expensive, the number of people who are willing to go to court come down. Now, this is one way of tackling the access to justice problem. The pendency problem. You don't increase the disposal rate, you reduce the filing rate. Okay? So one element of the Singapore strategy was effectively it tackled the filing rate by making litigation highly expensive. But there is a second element to the Singapore strategy that we might want to pay attention to. They focused on disciplining the court process. The moment you imposed costs, no client was willing to pay for a lawyer who came and argued for 2.5 hours. So the 2.5 hours cost also the client would have to pay. Right? So the court started putting in very disciplined oral argument requirements and then allowing for quick decisions. The moment you start producing decisions and determine periods of time, you get no. Will not by it will be decided by creating a system. 95% cases set on the civil can be side bargaining. And we have a plea bargaining system in place. A range of cases that the legal system reform increase the entitlement. Efficient court system is a court system that induces 90 to 95% of the cases after filing to settle. That is an efficient court system. So this is the effect of thinking of the legal system as a social process. You know, allowing parties know, oh, my decision on 15th on self-decision, because they know human beings. So let me stop there about Singapore. We can talk about Singapore on another day and maybe in greater detail. I haven't prepared a talk on review that experience and share more with you. Should I move on? I think
Yes,
Dr.
yes,
Kalpesh Kumar has
Please,
a question on ease of doing business. Ease of doing business takes a very short sample. Still, various policy making, how to address this issue. Can we go for ranking in 2 to 3 years? See, unfortunately, I mean, ease of doing business is exercise. They public office, so they have an automatic audience. I completely agree with you that the doing business really can't take it seriously. You know, take it as some kind of dipstick, small survey. Okay, it tells us that some people are happy with the legal system or not happy with the legal system. Not much more than that. Go to the survey every 2 years. Unfortunately, we don't have to agree. They will do the survey and they will publish the result anyway. So it is not that India, though, but I think your preferred ease of doing business as the measurement. So Chief Economic Advisor Arvind Subramaniam referred to it and said that India must adapt to this in the economic survey. What was it, about maybe 3-4 years ago, 5 years ago? Ever since then, it has kept repeating itself. Now it comes in Chief Economic Advisor's economic survey. It also comes into the budget discussion. So it has become in some ways the default way of looking